Good afternoon, everybody, and welcome to the second People Hour session that Gunnercooke's Employment and Pensions team are running. For those of you who don't know me, I'm Jo Tindall and I'm a partner in the Employment and Pensions team, and there's a nice picture of me there on the first slide. So for those who didn't tune into the last session, we'd be very keen to have your feedback. This is a new thing that we're doing, and the aim of these webinars is to provide you with an update on key employment law developments and look at the practical implications. So if you have any feedback about style or content, then please do feed it through to either me or to your usual Gunnercooke contact. So in terms of the format of today's session, it's going to last probably between 30 and 45 minutes, depending on whether we get any questions during the session. You do have the ability to ask questions. You should have a questions box up in front of you on your screen. So please feel free to send any questions through, and I'll do my best to answer them during the session. If I can't answer the question for any reason during the session, then please feel free to get in touch afterwards and I'll speak to you then about it, or alternatively contact your normal member of the Gunnercooke employment team. So in terms of what we're going to cover this session, well, firstly we're going to look at the tricky issue of holiday pay and overtime following the Fulton and Bear Scotland case. And I'm sure that you're all aware of this decision already, given the coverage that it's received in the press, and you'll be grappling with the issues which have come out of it. So we'll spend a bit of time on that case, and for that reason I'm not planning to cover too much else in a great deal of detail in this particular session. Following on from that, I'm going to look at the statistics which ACAS have recently brought out about the early conciliation scheme and how that's going. So that was the scheme introduced last April, which obliged employees or former employees to contact ACAS before bringing a claim to try and get it resolved before going to tribunal. And then lastly, I'm going to look at a recent case which concerns TUPE and harassment claims in the context of when the time limit for those harassment claims runs from. So firstly, looking at this very tricky issue of holiday pay and overtime, which I'm sure you've all been scratching your heads over. I think the background to this issue is that there is an inconsistency between the Working Time Directive and the Working Time Regulations, which has led to various challenges in the UK courts. So whereas the Working Time Directive says that holiday pay for working time purposes under the directive must be calculated by reference to normal remuneration, the Working Time Regulations say that it can be calculated based on basic pay where an employee has normal working hours. So we've had this consistency from 1998, but over recent years we've seen a number of first instance tribunal decisions which have challenged this decision successfully. But so far we haven't had any binding decision in the UK courts until now. And over the last month we've had a decision in the case of Fulton and others against Bear Scotland, and this is the first EAT decision we've had. So it's binding on employment tribunals throughout England and Scotland. And as we all know, or I'm sure that most of us know anyway, the case concerned non-guaranteed overtime. So overtime that the employer was not obliged to offer, but if it was offered, the employee had to work it. They were compelled to work it. And the case did not concern voluntary overtime, as in where the employee did not have any compulsion to work it, but I'm also going to go and look at that in a bit. What the EAT confirmed in this case is that Working Time Directive holiday entitlement, the pay for that must be calculated based on normal pay and not on basic pay. So it essentially said that the test under the Working Time Directive of normal remuneration is correct, and that's what should be used when calculating holiday pay. The EAT also gave some guidance on what amounts to normal pay, and they simply said that normal pay is that which is normally received. So it doesn't seem to take us a great deal further. However, they then went on to say that for pay to be normally received, it must be paid for a sufficient period of time to justify the label, and it must be directly linked to the work done. So in other words, if the pay is received on a temporary or an ad hoc basis, it would seem that it wouldn't satisfy the criteria of being paid for a sufficient period of time to justify the label of being normal pay. So looking at the particular overtime arrangements in the given case, they found that the overtime worked was regularly required and that there was a settled pattern of overtime. And it was clearly linked to the work done, because overtime is obviously about the work that is done. So in those circumstances, it constituted normal pay and therefore should have been taken into account in calculating Working Time Directive holiday pay. There was also this question of whether or not the working time regulations could be construed so as to be compatible with the Working Time Directive, given the difference in wording. And the EAT found on that it must have been Parliament's intention to comply with the Working Time Directive, and in view of that the working time regulations should be construed accordingly. So they managed to get around the fact that actually the wording is different by saying, well, that couldn't have been the intention of Parliament at the time. So what about voluntary overtime? Because the case did not specifically concern voluntary overtime. Well, we can't see any reason why the decision couldn't cover voluntary overtime, in that the commentary by the EAT is that holiday pay must be based on normal pay, and that is what is normally received. So therefore, if voluntary overtime is paid regularly and consistently and over a sufficient period of time to justify the label of being normal pay, then chances are it is likely to form part of normal pay, which is obviously going to be a grey area for lots of employers. Our view is that it's unlikely to cover sporadic overtime working or ad hoc overtime working, but if you had an employee who always works overtime every weekend consistently, even though it's a voluntary arrangement, then that may well be covered, although obviously those particular set of facts weren't tested by the EAT. So what about other payments which are normally received by employees outside overtime and outside their basic pay? Well, importantly, the case also considered a couple of allowances which were paid to the employees, and these were allowances which were made in respect of time spent travelling. There was an allowance called a radius allowance, and then also a payment called a travelling time payment. And for both of these payments, the EAT found that they also formed part of normal pay, as they were regularly made and were directly linked to work. The argument that was made by the employer was that these payments were not normal pay, as in fact they were ancillary payments to cover expenses. However, that was not accepted by the EAT, as they clearly did not directly relate to the cost of expenses and were in fact on top of expenses, and were a payment which was related to the work that was done by employees. So it follows from that that other allowances which are made regularly and consistently and which relate to the work done by employees, such as shift allowance payments and sociable hours payments, are also going to have to be factored into holiday pay, at least the Working Time Directive element of holiday pay going forward. Another key point which was considered by the EAT was how far back claims can go, and this is where there's some good news for employers, in that the EAT considered where holiday pay hasn't been paid over a period of time, based on this case and based on what we now know should be taken into account on holiday pay, then if over that period of time there has been a gap of 3 months or more between any failure to pay holiday pay, then the employee can only go back as far as the 3-month gap. So, in other words, if there is a gap of 3 months in taking holidays, then that's as far back as the employee can go. The other significant element of that finding was that obviously this decision only relates to working time holiday, and it does not relate to the additional working time regulation holiday. In other words, the additional 8 days leave beyond the 20 days leave that an employee gets per year. And therefore, in view of that, because the obligation is only to pay the additional pay for Working Time Directive holiday, it must follow that within any holiday year there's a period of time where that payment does not have to be made, and therefore it's very unlikely that an employee is going to be able to go back more than a year in respect of claims under the unlawful deduction from wages legislation. This particular point was a point that Unite had confirmed, has recently confirmed that it will not be appealing. There was initially some speculation as to whether it would appeal on this point, and in fact the EAT judge commented that this point may well be appealable. However, Unite are not going to be appealing this point, so for the time being it does give some comfort that these claims are not going to go back all the way to 1998, but will probably go back at the most a year in relation to the payment of holiday pay. However, I don't think that's the end of the story. There could be further challenges, and in particular we've got the Lock and British Gas case, which is coming up for hearing next in, I think it's February next year, and that may well look at the situation again, and the law on it may well change. Okay, so I've got a question here, and the question is, the EAT judgment did not specifically address bonus payments. What are your views on quarterly, biannual and annual discretionary bonus payments which focus on the quality of the work rather than the quantity or productivity, i.e. low customer complaints, etc.? The quality criteria are all unaffected by the taking of holiday, so there is no disincentive as such to take leave. Can such payments be said to amount to normal remuneration for the purposes of this case? Well, I think that's very much a grey area at the moment. Whether or not a payment which is made quarterly or annually could be said to be part of normal pay, I think is definitely up for debate. The cases that we've seen to date focus on payments which are regularly made, so which are received in an employee's pay packet each month on a regular basis, such as commission, such as overtime, etc., and don't seem to relate to bonus payments which are made on an annual or a discretionary basis. So my view is that there will be a reasonable argument for saying that they fall outside normal pay. However, I think it's important to look at the risk within the organisation and look at the potential cost. So for those type of payments, I think it is a question of watch this space, and I would be inclined to wait until there are some further guidance on the issue from the courts before saying that they constitute normal remuneration and should be taken into account. Okay, so looking at the practical implications of this decision, and we've already covered some of those already, the EAT judge in the case has stated that appeals against the decision, apart from on the time point, which we know is not going to be appealed, have poor prospects of success. So I think what that means is that we have to work on the basis that non-guaranteed overtime, which is regularly worked, must be included in holiday pay calculations going forward. Similarly, allowances which are directly linked to work and are more than mere expenses must also be included in holiday pay, because the indication is that even if there was an appeal, it's very unlikely that that appeal is going to be successful, and certainly that would be my view, having seen the way that case law has gone on these points. However, I think one of the key questions is whether there are other variable payments which may also require inclusion. Firstly, voluntary overtime. There's clearly a question about whether that should be included if it is settled and if it is worked for a sufficient period of time so it constitutes normal pay. And next, commission. We have the case of Lock and British Gas, which is going to be decided early next year, which specifically is going to deal with the point of commission, but the indications are that if commission is intrinsically linked to work done, then it is likely to be a factor which should be taken into account with holiday pay. So, how to approach the issue? Well, I think that unfortunately there isn't a one-size-fits-all answer. It's going to very much depend on the degree of risk within your organisation and also the appetite for risk that you have. But a sensible first step would be to work out the size of the issue by auditing your pay arrangements, looking at overtime, looking at allowances, and looking at commission in particular, because these are the areas where we have had cases already indicating that there is an issue, to assess the degree of risk in that respect, looking at both non-guaranteed and voluntary overtime in that context. Once you've done that and you've established which of those arrangements are directly linked to the work done and are regularly received, then it's about looking at what the potential cost is going to be, and one possibility may be to look at a sample of employees if you're a very large organisation in order to try and determine the potential cost. And I think part of that early determination is also, is this something which is clearly going to fall within normal pay, such as an allowance, as we've discussed, or overtime which is compulsory and regularly worked, or is it a grey area? So there might be certain areas which you decide to park and certain areas where you decide to take a different approach and deal with and include within holiday pay. Clearly another key issue is going to be the administration around this. The indication is, although we haven't got a firm ruling on this, that it would be a 12-week reference period which would be used to calculate holiday pay. And the reason I say it would be the indication is that that's the reference period, as we know, that's used for employees who don't have normal working hours. Potentially that in itself could lead to issues if you have employees who take more overtime within that 12-week period. And I think there's also an issue of whether you're going to differentiate between different types of holiday pay, so holiday pay under the Working Time Directive versus holiday pay which isn't under the Working Time Directive. So the choices which are available are either to make changes to the holiday pay calculation, in which case it's a question of deciding whether you're going to do it for the Working Time Directive proportion or for all of it, and also considering, are you going to make changes in relation to certain elements, so allowances only, and wait until overtime is clearer, particularly if you only use voluntary overtime, or are you going to take a different view? Or wait for the issue to be tested further, which is what you may want to do in the case of purely voluntary overtime, and set aside a budget for dealing with it. One of the advantages to changing your holiday pay arrangements now is that by doing so and by correcting the issue, if you like, you are then breaking the series of deductions for the purposes of a claim being made under the deductions legislation. So that is a benefit. Although I think the decision, as I've said, does provide some comfort that employees will only be able to go back so far in terms of that series of deductions. So we've had a couple more questions come in. So next question we've had is, would it be sensible for employers to deal with possible claims proactively and make adequate budget provision now, rather than face the prospect of a collective claim by groups of employees? Certainly, I think it's sensible to make provision and make adequate budget for the issues. I guess whether or not a decision is made to change the position will depend on the degree of risk within the organisation and also the nature of the payments concerned. But certainly if it is an organisation where there is a higher degree of risk, perhaps if it's a unionised organisation, and if there are those sorts of payments which are clearly going to fall within normal pay, then it's going to be sensible for changes to be made. Okay, so moving on to the last point on the slide. One point which you may want to do, whether or not you make the changes, is to look at your contracts and look at amending your contracts to provide that working time holiday under the Working Time Directive will be taken first within the holiday year. And in that way it's clear that that proportion comes first, and then any contractual and working time regulation holiday will come at the end of the holiday year. And in doing that, clearly you're making it clear what proportion is going to be paid at the different rate of overtime pay, holiday pay, if you decide to go down that route. Okay, so that was all I was going to talk about for now in relation to holiday pay. Conscious that it is a very hot topic, so if you do have any other queries, then please do feel free to send them through, and we will do our best to deal with them either to your normal contact or to me. So the next topic I was going to briefly touch on is in relation to the early conciliation scheme, which has been run since last April now by ACAS, and as I'm sure you're all aware, the scheme was put in place in order to try and resolve claims before they got to the tribunal stage. ACAS have recently published some statistics in relation to the early conciliation scheme, which they are saying is a sign of the success of the scheme, although whether that is actually the case or whether it's due to the fees which tribunals are currently operating is up for debate. So in the period from 6th April to 30th September 2014, 37,404 EC notifications were received by ACAS, and of that number of notifications, only 24% progressed to ET claims. So out of the remaining proportion, 18% of ET notifications resulted in a COP3 settlement. So based on those statistics, there was a whopping 58% of claims which were actually taken no further. And as I say, ACAS have been saying that this is a sign that the early conciliation scheme is working. A very small proportion of the notifications are actually becoming tribunal claims. But our view is it's very hard to say whether the scheme is working effectively, because the statistics may well indicate that firstly, employers are unwilling to settle cases without actually seeing details of the claim in writing. There's no details to provide, no obligation to provide any details at this stage. And secondly, employees obviously may be deterred from taking things further due to the fees. So whether or not the scheme is actually working as intended remains to be seen, but it's certainly clear that the proportion of claims coming through remains very low. So the final topic which I'm going to look at today is the case of Vernon and Azure Support Services. And this case was about when the time limit for harassment claims runs in the context of a cheapie transfer. So in this case, Ms Vernon was employed by Port Vale Football Club Limited as a sales manager for events, and her employment was transferred under cheapie to Azure Support Services, who were a supplier of Port Vale, on the 4th of July 2011. The transfer related to the transfer of a catering function from Port Vale to Azure. So Port Vale contracted out its catering function, and as a result of that contracting out exercise, Ms Vernon transferred over in her role. Subsequent to this, she was dismissed on 19th October 2011. And she was dismissed in relation to allegations that she'd had an inappropriate relationship with a footballer. And that's not a point I'm particularly going to be discussing in relation to this claim, but it's just relevant in terms of background. So after her employment had terminated, she brought a claim of sexual harassment relating to the conduct of a Mr. Bedding. Mr. Bedding was a Port Vale employee, and critically, he did not transfer to Azure. So she was working with him, alongside him, until the transfer date on 4th July 2011. And then following that, she became employed by Azure and he remained employed by Port Vale. However, she continued to have contact with him in the context of the contractual relationship between Azure and Port Vale, and she claimed that the harassment continued after the transfer date even though he was an employee of Port Vale. Port Vale and Azure had claims brought against them, and Azure sought to argue that the claim was out of time as the limitation period for the harassment claim ran from the date of transfer. So Ms Vernon would have had 3 months to bring her harassment claim, and as the claim wasn't brought until after she was dismissed on 19th October, she'd gone beyond that 3-month period. However, the EAT held that that wasn't correct and that you have to look at the test under the Equality Act, which is that the limitation period for harassment claims must run from the date of the conduct complained of, or the last act where there is a continuing act. And in this case, Ms Vernon was claiming that she'd experienced harassment by Mr Bedding up until 11th October 2011. So the claim was in time, even though Mr Bedding was not employed by Azure, and even though Mr Bedding was not responsible for his actions in that context. So in terms of the practical implications of this decision, well, it's obviously important that if you're on the receiving end of a cheaper transfer situation, appropriate due diligence is carried out in relation to potential harassment claims so that you know exactly what you're taking on in terms of employment liabilities. And where possible, to seek indemnities, and I appreciate that isn't always impossible when you're dealing with a contracting situation, but sometimes it will be. And an important point in this case was, of course, that the date from which the claim could be brought ran significantly after the transfer date. So in that context, it's important to be alive of the risk of ongoing harassment taking place. And that's going to be in a fairly limited context where there is ongoing contact between an employee in an old organisation and the employee in the new organisation. But you can see how that might happen in a situation where you've got contact still occurring between two contracting bodies, such that it could be that an employee alleges that somebody within the client organisation is continuing to harass them or bully them after the transfer date. So it's just being alive to the risk of that ongoing harassment taking place, and the fact that potentially it would mean that the limitation period for claims is extended. So that's it for today. Short and sweet session. I appreciate that, as I say, there may be some more questions about holiday pay. So if anyone does wish to ask any further questions now about holiday pay, then please do send them through, as we do have some more time to deal with those questions. If you have got any other questions about anything at all, then please feel free to use your usual gunnercooke contact. The next People Hour webinar is scheduled to take place on 12th January 2015, and your feedback about these sessions is most welcome, so please do send it through. And please also feel free to tell others about our webinars, as they are open to everybody. So do we have any further questions? I'll stay online in case there are any further questions that anyone wants to send through. Okay, it doesn't seem like we have any further questions, so thank you all for listening, and I hope you enjoyed the session.